Hi, and welcome to Academic Compliance Academy. In this video, I'm going to talk about soft law, hard law, and compliance. In general, we can divide law into having two different functional characteristics, soft law and hard law. So let's start with soft law. I found this great definition on soft law. That is, rules of conduct that are laid down in instruments which have not been attributed legally binding force as such, but nevertheless may have certain legal effects and are aimed at and may produce practical effect. So what does that mean? Well, in the key characteristic, soft law has a non-binding character, which means cannot be enforced directly by court, because you're not bound to do what soft law says. So, examples of soft law: certain recommendation, guidelines. We have good governance codes that have evolved over time, the last few decades at least. These codes give out some guidelines and recommendations on how you should have a diverse management, how you should divide management and ownership, and different types of recommendations just to have a good governance structure. But these are not binding. You don't have to do it. We don't have a 50-50 rule of male and female in executive boards as in Norway. It's not a general legal binding character. So that would be a soft law instrument. It could also be the UN Global Compact, where you sign on certain politically policy-driven agendas like anti-corruption. But in the end, no one will come after you if someone finds out that you did deal with a very corrupt state or something else. Because there's no binding element to what you're signing up for. You're simply strategizing and branding yourself on your belief system as an entity member state, and what you think, what you want to disclose about your own aim, core values, and strategy. So when we think about compliance, is soft law then relevant if it's non-enforceable? Well, yes, it is relevant, because when we look at the soft law instruments, these are typically founded on the general perception amongst society on how you should act, or at least the majority's vote on how things should be, because they are policy driven. So you need to assess it as, you know, that there's no legally binding character. So in that sense, you won't get a fine, but you might get punished by non-legal elements. That might be public shaming, or shitstorms. Even your stakeholders, your stocks might go down. And it's because it's in overall, the soft law is policy driven. So it's very hard to protect yourself, which is why some of these elements are so important to stay on top on. Because if you go out and disclose that you're fully transparent, and then someone finds documents, leaked documents or something, that disclose that you haven't been transparent at all, well, there's no necessarily legal binding characteristics regarding transparency, unless we're going into the legal area of accountant and stuff like that. But the shitstorm and the people's court and what you will experience for not being fully transparent because you disclose this overall policy, well, that will hit you. same account for the green agenda, anti-corruption, and some of the other things that I put out here. So when we talk about soft law, compliance is really relevant because soft law typically represents the nature and the belief of society, at least good society. So what about hard law? So here I blurred out the picture of the two figures trying to solve a puzzle, which I try to be the representative picture of soft law. And now we're back to a picture that everyone knows because it's classic law. Hard law refers to legal obligations that are binding on the parties involved and which can be legally enforced by a court or competent authorities. So it is exactly what you would think about when I say regulations or law. So it can, of course, be framed in multiple ways, and that is important how the legal framework is when we need to talk about compliance and hard law. I will get much more into this because we will try to dig a bit deeper into hard law. But just an example, I put out here the element of minimum requirement. So if we have a directive from the EU as a minimum directive, it is exactly what it is, what it says. It's a minimum requirement, which means, are you in a high risk area within the legal framework of a minimum directive? You need to, your compliance commitment need to be above the minimum directive, the requirement, because the requirement is a minimum, and that will be the baseline. So if you are considered as high risk, your product is high risk, your suppliers are high risk, your areas of sales are high risk, it would be a really good recommendation to say, okay, my compliance commitment here, no matter if this is a minimum directive, we need to have a standard above this minimum directive because it is risk-based and we are in a high risk surrounding. So that is when it comes to hard law and compliance. Typically, everyone who has worked within compliance knows hard law because it was the check the box list. I got here the checklist. Yes, we did this, we did this, we did this, we did this. So is there anything new when we talk about dynamic risk-based compliance and hard law? There is, of course, because instead of just going into every single requirement or statute to see if you comply, the initial idea behind dynamic risk compliance, and when you're in a risk-based regulatory area, that the idea is that you need to secure the aim of the regulation. So the single statutes might come with some limitations or requirements, but you need to secure that your risk assessment of your business aligns not only to the specific requirement, but also to the aim. And if there are any recommendations, even in the soft law area, that guides you in how to do so, you should try to implement those in your compliance commitment. I hope it makes sense. So when I made these slides ready, I was thinking myself, so is there a continuum between hard law and soft law? Because typically we would say no, because we have this clear threshold of course enforceability and that the legal instrument has a binding effect. So originally I would say not really, but I will point out that the risk-based regulation and when we talk about regulation now being risk-based, it has changed this. It's not a continuum per se, but soft law will have a direct input and effect on hard law. I put out an example here with the FATF guidelines in terms, so we will be in the area of money laundering and terrorism financing. FATF is an intergovernmental organization. They have recommendations on how to address money laundering, but they also go out and evaluate all the countries in different areas on how well their systems and operational systems are in the fight against money laundering and terrorist financing. And they rate these jurisdictions in a rating model, and some of them will be characterized as high risk. And because of that, that is actually within the soft law regime, because it's not a binding legal document, these recommendations or these risk assessment that FATF makes. But if you look into the EU law regarding money laundering, you will see that it is a part of the regulation that you need to look at the FATF guidelines. So before you know how to comply with the hard law, you actually also need to look here at a soft law parameter of a risk assessment, even though it's not hard law in itself. So you can see that even though we don't have this continuum, because we have a clear threshold, because FATF is still soft law, it's not hard law, because of the risk assessment and because of how we regulate, we use it as an inspirational source to then know how we should comply with hard law. So in that sense, soft law has gotten a larger effect in these areas when there are instruments and guidelines helping us do the risk assessment. So, hard law, soft law, and dynamic compliance. How should we put it up here? Well, what we need to assess here is the risk. We need to focus on risk being the glue that has kind of combined soft law and hard law even more together than under the reactive compliance regime. And because of dynamic compliance seeks to align business behavior internally and externally with society's principles and the expectations, soft law, the value of soft law and the knowledge of soft law when you need to determine your compliance commitment has increased. Of course, you always have to address hard law because that is a requirement. And on top of that, remember that you also need to address the aim between hard law, because that is also representing where are we going, and even if the requirement in the specific statute might not mitigate or limit your risk, well, then you might have to put your commitment higher, your standard higher, so your mitigation is in line with your risk exposure. So, to be compliant, you need to assess hard law and soft law in the connection with the present risk picture and secure that your business behavior aligns herewith while staying true to your own values and aims. Remember, core values, strategy, and the fundamental principles of your operation. So, this was a video on hard law, soft law, and compliance. Subscribe to the channel and stay tuned. Let's talk more compliance.